long back on 2020. And since then, continuously on every Friday, 4 to 6 p.m., we are doing these webinars for the benefit of the corporate and professionals. Today's topic is Insolvency and Bankruptcy Code, Amendment Act 2026, Key Reforms and Impact. As you are aware, on 6th April, this law is notified by Government of India. And previously we were doing some other webinar, but Mr. Madan has suggested that this is the topic, we should do this. So we have organized this program very short notice. But our purpose is always that whatever new is coming, we should be first to promote and to communicate to the industry and understand through the people, those who are part of the system, those who knows the law, that what is the interpretation and how to handle this, and whether it will be useful or it will create problem. So people should be ready. So friends, this Insolvency and Bankruptcy Amendment Act 2026 marks a significant evolution because every law is changing. It is bringing out something new, but this is one of the most important evolution in Indian insolvency framework, and which aimed to enhance efficiency, transparency, and creditor confidence in resolution process. The amendment introduced structural reforms across the corporate insolvency resolution process, liquidation, and newly introduced cross-border creditor-driven mechanism. The webinar which we have designed today, we want to provide a comprehensive analysis of recent amendments, focusing on their practical implication for insolvency professional, companies, creditor, and the legal practitioner. So it will decode key legislative changes, highlighting emerging trends, and assess how these reforms reshape the insolvency landscape in India. Because this was a one law which was dragging India in the for doing ease of doing business ranking always, because people were saying internationally, when you have a process of birth and the process of death is not there, then it is not a complete recycle of business. So in last few years, we have achieved a lot. We have seen this, and this law, which is an insolvency code, it has coming out a different way and different things. So I hope that participant will gain knowledge into the procedural changes, strengthening creditors' right, accountability mechanism, and the introduction of new resolution pathway. And that will enable everyone effectively navigate this particular new law. So today we will discuss various aspects. One is conceptual and structural changes, which is suggested by this particular amendment, strengthening admission and timeline, which is a part of this amendment, reforms and CIRP process, then enhanced role of committee of creditors, which they have given more power to them, and revolutionary introduction of creditor-initiated insolvency process, then major liquidation reforms, introduction of CIRP restoration mechanism, and pre-pack and voting threshold of changes. And then last, impact assessment we want to do on this particular changes. For this, we have invited people, those who are doing practice, people, those who have given decisions, people, those who have made this law. So I welcome first Dr. P.S.N. Prasad. Prasad is a former member of Judicial NCLT. He's a senior legal professional over 30 years of experience across judicial, regulatory, and corporate domain. He has served NCLT from 2019 to 2024, and he has adjudicated matter under the IBC and the Companies Act. He previously served as a senior legal role as a Reserve Bank of India, HUDCO 36 Moon Technology. Currently is a principal legal consultant and advocate at Mercury Law Hermitage, specializing in corporate law, arbitration, banking law, and regulatory compliances. I welcome Dr. Prashad. And in last program, uh, you have, though it was a very short notice for you that time, and but the way you have covered the aspects, despite of you were on the move, it was excellent, and your command over the subject and clarity over the issues were evident by your presentation. So I welcome you, sir, for our program. And today also we'll get new idea, new depth on this. Then I welcome Muklita Vijayvargiya. She is former whole-time member, IBBI, and served in the Executive Committee of the International Association of Insolvency Regulator. With over 40 years in legal field, she has worked as an advocate, academic, legislative draftsperson, and civil servant in Indian legal services. She previously served as the additional secretary in the Ministry of Law and Justice. And I think the most important introduction of her is that she has drafted over 100 principal laws of India, including Companies Act and various other laws which were there, and 3,000 plus subordinate legislative, including key work with bankruptcy law and reforms committee. So I welcome Madam, and I know I have interacted lots of time with you. The command over subject and command over whatever you have done is superb. And when we discuss with you, then we say one-sided of thing, but when you talk, you give a right perspective in the complete holistic view that why this law and how this will complete the process of legal scrutiny in the judicial court. So I welcome Madam for this program.
Thank you. Thank you.
And then we have Amit Gupta. He is a practicing company secretary and insolvency professional. Then we have a GP Madan. He's a founder managing partner, Madan Law Office. He's also insolvency professional and practice in the court. And he's a co-chair of he's a chairman, co-chair of SOCM, National Council of M&A, and he is the chairman of IBC Committee of PSD, Chamber of Commerce. Then we have Mr. Manoj Kumar, partner head M&A and investment banking, corporate professional. Manoj has looked after various merger amalgamation, and whenever there is a structuring issue is coming, then insolvency law and its future aspects is always coming in between. So I thank everyone for joining us. Friends, before I hand over to this, I'll just tell you what is the structure of this program. First, after my introductory speech, then Mr. Madan will discuss about these changes, and he will give the overview of this. And then Mr. Prashad and Ms. Muklita Vijayvargiya, Dr. Muklita Vijayvargiya, they will give their comments on this. And then we will have a panel discussion, come question answer session. And Mr. Prashad, Madam, Amit, Madan and Manoj all will participate. And we have identified around 40 questions. Some questions will come from the live webinar also, that we will cover every aspects and we'll discuss with everyone. So friends, before starting this, the insolvency code has one of the most transformative economic reforms in India. It has no doubt. And this is shifting from debtor in control regime to creditor-driven resolution framework. The most important statement I remember, Mr. M.S. Sahu, today we have invited him also, but he was not available, and so that's why we are missing him. The Mr. Sahu's one statement is this law is not for the managing the insolvency. The law is how people should avoid insolvency by the fear of this law. So it is really proving, because there are so many data which we can see in the court, that how many cases has come and how many resolution plan has passed. But we have no information that because of this particular law, how many cases has stopped and they have not come here. Because earlier in India, people were thinking that the creditors' money is their own money, and if they are a litigant mind, they can file in the court and they are aware that after 5 years, 10 years, the case will continue, and then that time I will pay money. That was the mindset. But because of the insolvency law and the way the big giant, one of the biggest example, Tata taking over the company of Bhushan. That is one example where people have realized, and I have done the work of Tata. So I went, it was a chance that I went to the office of Bhushan earlier, and I went office after the Tata taken over to that company then. And I realized, and I mentioned this, it is a silent coup, which is without any bloodbath. The management has changed, and that credit goes to insolvency law. So this 2026 amendment is not just a legal update, it's a structured recalibration which is taking place. At one level, it reflects a clear regulatory intent to reduce delay. That was a specific comment on everyone that though law is mentioning this, but delay is still there, and delay means the value erosion. To strengthen creditors' confidence, that is the second part. That is because so many people were saying, despite of this law, I have give money and I'm not getting proper resolution. And the most important thing is to bring more commercial discipline into the system, which I had just mentioned, that when people will have a fear that if I will do something, then the insolvency law will take over my company and my management. And the biggest important hurdle is that it is not that you manage certain things. If application is filed and it's admitted, then you are out from the management. That is the biggest fear, and this fear is really working out nowadays. So at another level, it introduces a fundamental shift from purely code-driven process to hybrid, creator-led mechanism. And the real question is today is not what the law says. What we have to see this, what direction the ecosystem is moving towards. Because the law is evolving, and slowly it is evolving. So we should not bother about what law is saying. Whether this is creating something great for the ecosystem that includes the insolvency resolution, as well as people should have a fear not to go for this part, and they at the beginning they should settle this issue. So I would like to frame today's discussion into two parts and two very important questions which are there, and I will expect Dr. Prashad and Dr. Muklita, madam, that we should see, are we moving towards efficiency or we are adding complexity in another form? Because when law comes, we just see that, okay, this is a new thing, it will solve that problem for which they are bringing out. But sometimes what is happening, it is bringing out something differently and negatively. Second question, how do we balance speed of resolution with fairness and value maximization? Because in Indian judicial system, we have seen cases of 10 years, even a company which is going for winding up, they were taking 20 years. And now we are talking about the 240 days, 300 days, 180 days. So this speed and then court burden is also there. Whether it can justify fairness and value maximization, or we are hushing up the cases because of the speed, we want to do this. So with all these perspectives, we will discuss today, and these are the two major aspects we will do this. And I hope that everyone will like, and all the participants, I'll request any question, any query there, you please write in the inbox, and we'll give a reply to all of you. So, Mr. Madan, now it is your turn to tell us about the aspects of this law, the basic point, major point, so everybody is on same page, and then we will start analytical discussion, the impact and the other aspects of this particular law, that where it is creating problem or solving problem, or what is missing, they have to come out. Over to you, Mr. G.P. Madan.
Thank you, Pawanji. Thank you for giving me this opportunity, and congratulations to you and your team for this 260th consecutive webinar. Some people say that COVID was bad, but COVID has proved to be a boon for corporate professionals. My gratitude to Dr. PSN Prasad and Dr. Mukulita Vijayvargiya, before whom I had the privilege of presenting myself, my cases before Dr. PSN Prasad in NCLT and before Dr. Mukulita Vijayvargiya as a disciplinary committee of Insolvency and Bankruptcy Board of India. And today I'm again privileged to share this virtual dais with both of them. My compliments to my both panelists also, Amit and Manoj. Pawanji, you have given a brief overview of the need for this Insolvency and Bankruptcy Amendment Code 2026. During this half an hour, I'll be giving a brief overview of this entire Amendment Act because if we go through the details and nitty-gritties of this entire Amendment Act, it will not take less than 2 full days because there is so much in this Amendment Act. So I'll give a brief overview of this and may I request my dear friend Mr. Shivam if he can share my PPT on the screen. Shivam, are you doing it, please?
Yeah, he's doing.
Okay, thank you. Shivam, next slide, please. This is the first page only. Please, next slide. Shivam, how can you remove this big logo which is coming over the slide? Is it possible to remove this?
No, sir.
No?
No, sir.
What is it covering the PPT? Anyway.
Come tell somebody to remove this till the time you just show it.
Okay, yes,
Okay, sir.
please. You know, earlier what was happening, as the first bullet says here, that why did we need this Amendment Act? That it was being said that there have been persistent delays in admission and approval stages before NCLT, and there was a lot of backlog before NCLT and NCLAT. And many a times, the stakeholder used to say that there has been delay on the part of NCLT. But let me share with all of you that there has not been any delay on the part of NCLT. NCLT had its own limitations. NCLT was constituted under Companies Act for the purpose of Companies Act. Later on in the year 2016, this additional burden was given to NCLT by Insolvency and Bankruptcy Code 2016 because the code wanted an adjudicating authority for the corporate persons, and the same NCLT which was already there constituted in the year 2016 itself on 1st of June 2016, the same NCLT was given this nomenclature of adjudicating authority under IBC 2016. So for the purposes of Companies Act 2013, it's a tribunal, and for the purposes of the IBC, it is the adjudicating authority. Now, the numbers which were given to NCLT was 63 total number of members. This number was never increased. Rather, at no given point of time, we saw the 63 even full strength. Last year, I presented this case to Standing Committee on Finance when the bill was to be drafted. I gave this submission to Standing Committee on Finance that we need more number of benches, we need more number of members, and we need some better infrastructure also. Then once the bill was out, I presented my case before the Parliamentary Select Committee also. And there also I prayed to them, whatever changes you bring, because in the proposed Amendment Act, you are bringing so many changes, so many timelines, 30 days, 30 days, 30 days, 15 days, 90 days. All these changes are not it's not practically possible to implement those amendments unless you have full number of NCLT benches in place, unless you have the members and unless you have the infrastructure. Because in the proposed act, you are writing that the reasons are to be given in writing if you are not able to dispose of the matter within a stipulated time period. And I tell you, some of the benches have already started doing it. They are already writing in their orders that it is already 1 o'clock. There's a technical members who have to sit in the other court, or in this room, the court room is not available. Therefore, the matter is adjourned to such and such date. Now, the reasons are genuine that we do not have infrastructure. So, reasons are being given. But thank God now the government has started listening to our demands. And from Monday onwards, 20th of April 2026 onwards, at least two of the benches in Delhi are going to sit for full days in a different building. But that will have its own ramifications because that is a different building. From one building to another building, how one will move, I don't know. And it is going to take 10 minutes of walking from moving from one building to another building. And in the same complex, I cannot go by car because there is so much of traffic in that area. And sometimes the cars of the advocates are not allowed within the premises also. They have to stand park outside. Anyway, the backlog which was there, the backlog was there because of the infrastructure, not on account of NCLT. The structural gap which was there was misuse of insolvency proceedings for recovery purpose. The intention of this legislation is rehabilitation, revival, restructuring, resolution, and not recovery. But I tell you, in almost all the cases, there is no exception at all. In all the cases, the applications, be it under section 7, 9, or 10, have been filed. No, not under 10. Under 7 and 9, these applications have been filed only for the purpose of recovery by the financial creditor or the operational creditor, as the case may be. And in section 10, barring exceptions, majority of the applications have been filed for the purposes of ultimate liquidation. Gross misuse of section 10. Actually, that was provided with a laudable objective of giving an exit. But majority of the promoters misuse section 10 provision. Then the issues which were there earlier, that was with respect to the claims which are being filed once the plan has been approved either by the adjudicating authority or before that either by the committee of creditors. What will the treatment of the claims which will be filed later on? So many such issues were there. Now the which issues have been clarified in this amendment act. And the couple of other issues which were there, no reply was there earlier, that was with respect to group insolvency and the cross-border insolvency. Now the enabling provisions have been provided in this Amendment Act, and the government will come out with the regulations. Ministry of Corporate Affairs may come out with some rules, and then these provisions may be implemented in letter and spirit. Now, how these issues are being addressed in the proposed Amendment Act? One of the proposed amendment is that is with respect to introduction of creditors initiated insolvency resolution process, CIRP. But this CIRP cannot be implemented unless we have the regulations in place. Draft regulations have come from IBBI day before yesterday. The draft regulations have the discussion paper on the draft regulations have been placed before the stakeholders for their feedback. And once this feedback is there, the IBBI may come out with the final regulations and then CIRP may be implemented. Actually, this is being called as out of court settlement also. Without going to NCLT, how can there be a resolution which can be initiated by the creditors? And during this entire process of resolution, insolvency resolutions, the control will remain with the creditors while the possession will remain with the debtors, that is promoters only. So it is going to be a hybrid system like in earlier BIFR mechanism. A part of this we have seen, but we should also remember that BIFR was a big failure. Now, the issue is, can there be a out of court settlement? I leave it to the Dr. PSN Prasad and Dr. Mukulita Madam. I'm not going to comment on this. Then another is that enhancing timelines and reducing judicial delays. Why actually are being curtailed? Now, if we see the timelines in the next slide, if you come to this, Shivam, can you come to the next slide, please? Yes. For admission of section 7, 9 and 10 applications, NCLT has been given only 14 days. 14 days from the date of receipt of the application. And what is the date of receipt of the application? That has been clarified by Honorable Supreme Court in the year 2017 itself in innovative judgment. The date of receipt is the date on which the application is first listed before NCLT. So from that date, within 14 days, these applications are to be admitted or rejected, which is absolutely a Herculean task. According to me, this is not a practical amendment. It is not practically possible to be implemented because the courts are bound not only by this code, courts are also bound by principles of natural justice. So unless principles of natural justice are followed, the other party is given an opportunity, other party is given an opportunity to file the reply, then there may be rejoinder, then there may be arguments, then there may be further evidences. Unless this entire pleading is complete, application cannot be admitted. But incidentally, what is happening in this case now in section 7, the word may has been replaced with the word shall. Now, the moment a debt is there and default is there, and the evidence of default is there before NCLT, NCLT will have no other option but to admit Section 7 application. And the best use of this provision would be to have a record of default with the information utility. The moment that ROD is there and ROD is placed before the bench, NCLT will not apply its mind at all, and NCLT is not expected to apply its mind. To me, this is not a good provision, to be very frank, because of this new act. Now this legislation may become a recovery legislation rather than an insolvency resolution legislation. Because even now a solvent company can also be sent to insolvency. The law which was laid down in Vidarbha, that law has been taken care of. And while considering that law, this amendment has been proposed that we do not agree with that law, which was laid down by Honorable Supreme Court, that please do not send a solvent company to insolvency. But later on, actually, Supreme Court itself changed the law by passing another judicial pronouncement in another case where one of the RPs was a respondent, and Supreme Court decided once the debt is there and default is there, NCLT will not go into the merits of the case, the merits of the default, and NCLT is duty bound to admit the application. Therefore, now in the proposed section 7, the word may has been replaced with word shall. NCLT no jurisdiction at all. So in 3 cases, 14 days period is there. Then, in case a resolution plan approval application is preferred before adjudicating authority has to approve the plan or reject the plan within a period of 30 days only, against the present practice of 1 year to 2 years to 3 years. The plans are pending before NCLT. Once a plan is filed, after that many objectors come before NCLT, they file their objections to the plan, and NCLT hears all those objections. And after hearing the objections, then only the plan is in the commercial wisdom of COC principle, and NCLT has limited jurisdiction to see only that whether the plan is in compliance of section 30 subsection 2 or not, nothing beyond that. Another timeline which has been prescribed is that is in case of a liquidation application is preferred before NCLT, NCLT has to decide this application within 30 days. And after liquidation, when a dissolution application is preferred before NCLT, NCLT has to decide this dissolution application also within a period of 30 days. Surprisingly, there is another timeline under the act proposed under this amendment act. Let me tell before to everybody that as on date, this act is there. This act has been published in the official gazette, but the provisions of the amendment act have not been notified. And the amendment act says that the different provisions of the act may be notified from different dates by the central government. So unless a provision is notified, this will not come into effect. Notification will be there by Ministry of Corporate Affairs. And majority of the proposed amendments are subject to the regulations, and regulations will be brought by IBBI. So unless we have those regulations in place, the provisions of the Amendment Act cannot be notified. But IBBI has also already started this process, and I'm pretty sure from the next month onward, the provisions of this Amendment Act may be notified in phases. Now, what I'm saying that the Act is also providing for a new timeline for NCLAT, that NCLAT shall decide an appeal which has been preferred under Section 61 within a period of 3 months. But incidentally, this is 3 months, this is not 90 days. And whenever we count 3 months, suppose we are in the month of April, if an appeal is filed today, 17th of April, for all practical purposes, if it is 90 days, it has to be decided by 16th of July. But if we say 3 months, then the entire month of July shall be counted. So it can be decided by 31st of July. This is what my interpretation is. But deciding an appeal within a period of 3 months is also a Herculean task. Anyway, why all this has happened? Because in ArcelorMittal versus Satish Kumar Gupta, Supreme Court has already decided that timelines are the backbone of IBC and must be strictly adhered to. Coming to the previous slide, Shivam, please, previous slide. Shivam, are you there? Yeah, previous slide. Yeah, the last bullet on the right-hand side. This Amendment Act is actually providing statutory backing to various judicial pronouncements which have been there. We have the IBC 2016. After that, there have been many judicial pronouncements from Honorable Supreme Court and some judicial pronouncements from Honorable Appellate Authority which have not gone to Supreme Court. And those final judgments of NCLAT and final judgments of Supreme Court have become law of the land. Now, wherever that was not existing in IBC code, what the government has done, government has now through this amendment tax has brought the ratios of those judgments of Honorable Supreme Court and Honorable NCLAT in the Amendment Act. A law which was laid down through judicial pronouncement that has been codified now in this Amendment Act. Shivam, next slide, please. On this CIRP, I would not like to speak because I think, Pavanji, I would prefer that once we have this all the regulations in place by next month, maybe we can have a separate webinar on this entire CIRP, Creditors Initiated Insolvency Resolution Process. In nutshell, this CIRP is an arrangement between the creditors and the debtor. The creditors having 51% consent of its own class, not 51% of the all creditors or 51% of the secured creditor, 51% of its own class can talk to the CD that you are in default. Let's try to have some resolution mechanisms for you. For this purpose, RP shall be appointed. 150 days have been provided for this. This period may be extended by another 45 days. Moratorium may be there, may not be there. For the purpose of moratorium, one has to file an application before NCLT, and only NCLT can allow moratorium. If moratorium is not applied for or not granted by NCLT, no moratorium is there. It means in this period, all the legal proceedings can be initiated against the CD and existing legal proceedings can continue against the CD. So it seems to be a very, very, that's what they're calling it out of court settlement. Only court stamping will be there. And let's hope this works fine. And I'm really happy about this, that if this process is initiated and backed by the regulations, this is implemented. Because what we have seen earlier, PPIRP provisions which came there 5 years ago have miserably failed. And government knows this very well. And because the PPIRP provisions failed, now the government has come out with CIRP. That is the only objective. And tomorrow CIRP will replace the PPIRP. Next slide, please. Next to next. Next to next, please. Yeah. In Ghanshyam Mishra, as well as in the Essar Steel case, Honorable Supreme Court has already decided that a resolution applicant shall get the corporate debtor on a clean slate. Actually, this has been already been provided in section 32A of the existing code, but now it has been clarified in more detail. To me, all this is nothing but clarification because we have an existing provision in place. So what is being clarified now that all the prior claims prior to CIRP, they shall stand extinguished if they have not been filed, have not been considered in the CIRP. All those claims shall stand extinguished. No proceeding which was initiated prior to CIRP can continue once the plan is approved and the company has been given to the successful resolution applicant. All those proceedings shall get extinguished, shall abate. All the existing licenses, permits, and concessions will not get terminated post resolution of the corporate debtor. However, if any new fee is to be paid, that shall be paid by the SRA. But for earlier existing dues, these permits, licenses, concessions shall not be withdrawn, shall not be terminated. Next page, please. Yes. Committee of creditors has been given now a greater role in liquidation also. That is very major change in this
सर
amendment
आप
act.
अपना कनेक्शन जरा चेक कर लीजिए, कनेक्शन थोड़ा सा आपका वॉइस ब्रेक हो रहा है बीच बीच में.
My connection.
या
Okay. Sorry. Give me. Am I audible now?
yes
Yeah.
audible. Yeah.
Yes.
Okay. It will be. It should be better. My bad. My apologies, please. So now the COC is going to supervise the entire liquidation process. Also, the powers of the liquidator have been reduced. And even it has also been provided now. There was a communication from IBBI in the year 2023 in the month of January to NCLT that wherever there is no resolution plan from the COC and the company is being sent to liquidation, the RP shall not be appointed liquidator. This provision was challenged in many cases, and in one case, Honorable NCLT decided that mere communication from IBBI to NCLT cannot override their judicial provision, the legislative provision. Therefore, that particular communication was held to be ultra virus. But now, honoring that communication of IBBI to NCLT, there is an amendment is proposed in this Amendment Act that wherever there is no resolution plan, the RP shall not be appointed as liquidator. It is being presumed, according to me, that if there is no plan, it is because of RP. So the RP is responsible for this if there is no resolution plan. And now, after this amendment comes into force, the RP shall endeavor his best. Rather, he would like to prolong the entire CRP process to ensure that there is a resolution plan, the company does not go into liquidation. Earlier, the one incentive was also there, which was being said. There was an allegation that many RPs prefer liquidation over resolution because in liquidation they get better fee rather than the fee which they get in CIRP. I don't know to what extent that allegation is true. Anyway, another major change which is being introduced now is once there is no resolution plan, and COC is now, as per law, is mandated to recommend liquidation. at that point of time, COC has been given now another right to file an application by passing a resolution with 66% majority. To file an application before adjudicating authority, they please give us one more chance. We want to reinitiate CIRP. No doubt for this purpose, the timeline is shorter, but one more attempt to stop the company from sending to liquidation and one more attempt for the revival of this insolvent company. Very, very laudable provision. I really like this provision. Next slide, please. Yes. For liquidation, earlier there was a timeline of 1 year, and after 1 year, this timeline was being extended multiple times. You file an application and adjudicator used to give extension of a liquidation period. But now it is being said that liquidation shall be completed within 180 days, and this period can be extended by 90 days. And incidentally, there is no further provision which talks about further extension. If you read the language of the code, this 180 days plus 90 days, this timeline is sacrosanct. And even though no discretionary power with the adjudicating authority to extend this liquidation period, would like to have the views of Dr. Prasad on this later on. COC has also got the power now, the post liquidation, to replace a liquidator also. So first of all, RP cannot become liquidator, and second, when a new IP becomes liquidator from the panel of which is there with the insolvent with NCLT, even that liquidator can also be replaced now. So far, there is no provision of replacement of liquidator, but now there is a provision in the code that liquidator can also be replaced by this committee of creditors. Next, please. You must have seen, friends, the group insolvency, though it's not part of the code, in case of Videocon or in case of SRE Group. We have seen some of the group insolvencies. Now, the group insolvency will be part of the legislation. Section 59A is being introduced. Rules and regulations will follow. And on compliance with rules and regulations, group companies, if one company goes into into CIRP, another company may also be sent to liquidate to CIRP. If there are two or more companies, there can be a common committee of creditors, there can be a common resolution professional, there can be a common resolution plan also. All this is going to save the time, energy, and resources. Very, very laudable provision. Only thing is that the implementation may take some time, and implementation will see lot of judicial review before the adjudicating authority and appellate authority. With respect to cross-border insolvency, actually I am receiving reports from the outside countries also that many countries are waiting for this provision to be introduced in India, that when this cross-border insolvency will be there. Once an enabling provision has come now, once this provision is introduced, implemented, effective, made effective, I tell you, there's a golden opportunity for the professionals who are working in this place. Very major shift is going to be there, and all the professionals like you and me will get a tremendous opportunity, and we'll have now going to have now international exposure. So those who have not studied it so far, please read the cross-border insolvency provisions of this proposed, because there have been many discussion paper in India. Also go through the insolvency mechanism of outside countries and then try to follow and implement it ASAP. Next slide, please. In case of avoidance transactions, excellent provision has been introduced now. Earlier, what was happening, the admission was taking not less than a year in majority of the cases. Once you file an application admission takes not less than 1 year. And all these transactions, preferential, avoidance, or extortionate, they were being seen 12 months prior to company goes into insolvency. And every promoter knew it. Before an application is preferred, immediately within next 1 or 2 months, take everything out of the company. So you do not come within the ambit of 12 months prior to CIRP, because the CIRP at 7 or 9 admission has taken more than a year. But now they say, please calculate this period. The 12 months period will start from the date of filing of the application. So 12 months period prior to filing of the application ending on the CIRP commencement date. If any preferential transaction, extortionate transaction, avoidance transaction has taken place in this period, that will be part of the avoidance, that will be treated avoidance transaction. A very, very the laudable change, and the actually demotivating the promoters to take any action against the interest of the stakeholders. Last couple of slides. One is with respect to decriminalization of offenses. No doubt, in many places, heavy penalties have been imposed. But in majority of the cases, the words fine or imprisonment are going to be replaced with the word penalty. Penalty shall be levied adjudicated by the adjudicating authority. One, you need not go to the court of law. So special court will not have jurisdiction to deal with the offences under the code wherever the word fine or wherever the word imprisonment is there, and now going to be replaced with the word penalty. And the last change which I would like to share with all of you, that's not part of this PPT, that is with respect to withdrawal under 12A. Prasad sir, you have allowed many applications of withdrawal.
Yes.
Prior to, sir, you are logged in 2 devices, I think.
Sir, you have to, I think one device you have to disconnect, sir.
Yes.
This device is perfect, another is coming. So
जहां आपका फेस नहीं आ रहा वो वाली बंद कर दी, जहां फेस आ रहा है वो अच्छा है, इतना ब्यूटीफुल फेस दिख रहा है आपका. In case of section 12A, there was a regulation that prior to constitution of the committee of creditors, if an application is preferred under form with form FA under section 12A and under regulation 30A, prior to constitution of the COC, an application will be preferred before the adjudicating authority, and invariably adjudicating authority passes an order for withdrawal of the application. But now no withdrawal can happen before constitution of the COC. Withdrawal has to go to COC. 90% of the COC members have to approve the withdrawal. Then only withdrawal can be done. Withdrawal can be approved. This is according to me, my personal view, is a draconian provision. Because now the moment a company is admitted to insolvency, it is next to impossible to take it out, because 90% approval of the COC is an impossible task that will not be there. I hope in the times to come the government dilutes this provision. Earlier also this provision was diluted by IBBI only. It was not diluted by the code. Code talked about 90%, but IBBI came out with regulations. I wish IBBI again comes out with regulation in the interest of the corporate debtors and the companies saved from the rigors of the insolvency and bankruptcy code. So Pawanji, these were some of the amendments from my side. Now please take it over. Thank you.
Thank you, Mr. GP Madan. Thank you for giving a lucid and concluding a good presentation which anybody can understand with your commentary. Now you will get another chance also. Sir, Prashad sir, now this law is before you and you have given so many judgments, so many things under your judicial scrutiny has passed. And whenever you are finding whenever you are giving any judgment, then you must be feeling your hand but tight because you have to follow the law. But sometime you must be thinking that this law should have changed like this. Now law has changed and so many things. So in your opinion, What is your view on this, the new amendment? How this will helpful? How this particular amendment which has come will reduce the pain of creditors, insolvency, insolvent companies? Because aim of insolvency law was not to bind up, not the close. The thing was that how we can revive this company with the legal at one source program. Over to you, sir, for your views.
Yeah. First, let me thank you and uh, Brother Advocate GP Badan for excellent way of bringing the topic and structured it in such a nice way to take it further. In fact, according to me, the era of 2020 has begun. That means the 5-day cricket match is over now. Now we are stepped into 2020 era. And all these time schedules, we were also thinking that we should very strictly follow. But the impossibility is because of the infrastructural constraints and the pleading ability of our advocate friends. Actually, the time schedules are warranted, and all the stakeholders, not only the NCLT has a responsibility to stick the time schedules, even the advocates representing the clients and the clients themselves have to say to their advocates, let us see that our matter is concluded within the time prescribed under law. If the client comes and asks the advocate, please take an adjournment, what advocate will do? He will not say, I will not take adjournment. Or maximum, he will come and say before the court, short adjournment may be given. Actually, there should be these webinars which speaks about the speedy resolution of the entire CARP process have to be put into the mind of all stakeholders. Stakeholders have to change their attitude, and it is not very difficult when stakeholders are cooperating before the adjudicating authority. Adjudicating authority's job will become easy. If the stakeholders doesn't cooperate, though the spirit of law says this need to be adjudicated within the time frame given, and if the people are not, if the advocates, clients, they generally they come and say some instructions have to be received from the client. Just give us 2 days time. Then the causes like client getting hospitalized, client being at abroad, all these things advocates have to forget. The moment they get a section 7, section 9 or section 10 application, advocate must be mentally prepared to file his reply within the next 24 hours. If advocate is ready to file his reply within the next 24 hours, maximum 1 day time should be given for filing rejoinder and also other processes, and hearing can be very quick. It is the time where the pleadings takes much time, and cutting the time in pleadings is in the hands of entire advocate community and the stakeholder community. If the stakeholder community and advocate community comes forward to stick to the time schedules, irrespective of all other constraints, because during COVID also we worked, and during other constraints period also we have worked. We have conducted courts from our house. So it is not difficult when the stakeholders in the system, are trying to cooperate and work within the time schedules. Actually, these amendments are nothing but a reflection, as GP Madan rightly said, reflection of the reflection of the judgments which were given by NCLT, NCLAT, and the Apex Court. And some judgments which Apex Court have been given have been seen from the angle whether they really facilitate the creditors regime or not. And if the creditors regime is not facilitated by those judgments, the IBBA has now suggested modifications to law to see that IBC is to establish the creditors regime and not the debtors play home. In fact, I welcome all these amendments, and these amendments have come right from, I think, from last 6 to 7 years, there are no concrete amendments. And now only the concrete amendments have come after the enactment, and these amendments are very much warranted. In fact, our insolvency and bankruptcy law, until we bring the group insolvency as well as the cross-border insolvency into full play, we can say that we were a step backward when uh, compared with existing insolvency regimes across the globe. So, of course, these have to be tested. 59A and the other provision is also have to be tested along supporting rules and all. But still, as according to me, these amendments are very much warranted, and these amendments apparently going to bring major changes in the working system of adjudicating authority, as well as approach of the advocates, as well as approach of the clients. And this law now sure of creating a deterrent fear of taking remedy under under NCLT. If the creditor approaches the NCLT invoking the provisions of IBC, immediately the debtor will run and try to resolve the problem before it actually taken up for hearing. In my view, this law in its present amendment shape is going to create more deterrence on the borrower to think twice before defaulting, because time schedules are very tight and discretions have been lessened, and even to the appellate authority time schedule is prescribed. So everywhere, everybody is running under pressure of time. When pressure of time works, it really creates a kind of lot of system running totally fast. And in this confluence of forces, sometimes it may give some kind of ill effects, but these ill effects are right now cannot be predicted. But as it is, law is not going to deprive the principles of natural justice. I don't feel this law now in its amended form is going to deprive the principles of natural justice or any other fair opportunity. Only the thing, the mostly it is in the hands of those friends who are appearing before the courts, and they should educate their clients that we have to certainly answer the court on this point within this time. There is a need for change of thinking among the stakeholders in the system. This is a good law, according to me, to the extent what I understood, what I heard, and what I personally observed.
You take 2 minutes take break, sir.
पांडे जी पानी पिलाओ सर को.
So this is a that way. very good,
Sir, you take
very
break,
good
please.
law. And in fact, I would like to uh, take my first spell of talk now and pass it on to next speaker. Thank you.
Okay, thank you very much, sir. Your point are very nicely covered, and the point which you are saying is really depth of knowledge is reflecting. What I'll when we'll come to the question answer, and my various questions are there which you have raised just now. I'll cover up this part. Now, Madam Mukulita, Madam, you have made law. You have not only made this particular law, but you have made various other laws, and you have worked, and you know the depth of particular issues, that how things moves, how these issues are handled, and why this interpretational issue is coming despite of uh, problems in earlier in the court. So over to you and your view on this particular thing. You're open and you can talk anything, madam.
Thank you, Mr. Pankumarji. I also thank Mr. G.B. Madanji and Mr. Prasad for expressing their views on the recently enacted amendment of the Insolvency and Bankruptcy Code. Thank you very much. It has given me some inspiration, indication of the implications which this Amendment Act will bring out. First of all, this law is a procedural law, and procedure is very important. No doubt the procedure needs to be changed from time to time as per the demand of the market or as per the experience or the cases which were before the NCLT, and there were some lacuna found or some kind of missing gaps found. That's why the amendment has taken place. But frankly speaking, what I view is that there is lot of duplication in the enactment, number one. Secondly, the provisions have been already provided, but I think there is a repetition which makes no sense and not a healthy practice for any draft person. It has changed number of definitions, inserted number of definitions, and I think if I dissect the definitions, I will come out. I will come to the definitions. I think after a little while, but we'll find the definitions determine the scope of the act. Every word of the definition is very important. If you write any other, and if you write any such other person, that makes a lot of difference, because you then you spell out the category of persons which is followed by the preceding categories. So certainly the definitions are defective and may give rise to interpretation, and certainly for interpretation it will go to the court of records, High Court or Supreme Court. Anyways, then this law has brought new kind of CRP, which I am surprised, because company is a company. Company may be decided into public company or the private company, but juristic person, both are juristic person, and for both of them the limit has been given regarding the default, but the process would be the same, the creditors would be the same. There is a class of creditors, there will be resolution professional. Secondly, the resolution professional includes liquidator, it includes interim resolution professional as per definition, but confusion has been created that it includes the interim resolution professional. Earlier also it included resolution professional interim for the period 30 days. So unnecessary giving explanation again, I think that will confuse the stakeholders. Secondly, in section 5, there is an explanation. I think Mr. Pawan Vijay Saab would like to would like to resolve or give some strategy for resolution of that. There is in section 5, clause 20, clause 6, explanation means merger, demerger, amalgamation. Then say through one or more plans proposed by one or more resolution applicants. There will be only one plan which will be accepted, approved. One or more plans, and it will not, sale will not be part of merger, demerger, amalgamation. The category doesn't fit in. As per the maxims of interpretation, I think here also some confusion will be there, and maybe the process may become more complicated. Then in section 10(4) also there is no description. Under section 12 also there are two conditions for withdrawal. and constitution of the committee, when you have to get it approved by the committee, that means it presupposes the constitution of the committee. Then no need of writing that condition. No need of writing, because you are saying that it has to be approved by the committee of creditors by 90%. Certainly there would be committee of creditors then only. So the conditions which have been proposed, two conditions have been proposed. I think the other condition was the first invitee, first resolution plan, first invite of the resolution plan. I think that also appears to be frivolous, because when the committee is constituted and you want to refuse or you want to prevent withdrawal, then I think and the condition are such that there is no or, it is and. There is either this or the and that. That means you have to fulfill two conditions. One is the constitution of the committee, and other is the that invitation of the resolution plan. I think here mind has not been applied by the draftsman, in my view. I'm not saying I'm not the market person, but I feel that that would be more harassing for withdrawal, because withdrawal, the person who is initiated, made an application, should be given a chance to withdraw. I mean, ease of doing business means not preventing, harassing, or imposing something, but facilitating the process. And if you put too many conditions, then certainly the withdrawal process would be would not be there. People would not be able to withdraw it, and there will be a number of cases even for this interpretation also. Then in case of resolution professionals, I already spoken that it includes everybody. I think one question was raised by Mr. Pawan Kumar Vijay about efficiency and complexity. Certainly the provisions are complex. They will provisions are written in simple language, no doubt, but they will give rise to complexity. Things which can be done through rules should not have been here in the act, because to amend the rules is more flexible than the amendment of the act. How regarding speed, number of points we find timelines. If there are timelines, the process has to be mechanical, totally mechanical. And it is a judicial process because it is before the tribunal, a quasi-judicial body. Discretion needs to be given to them, because every case has a different fact. There is a different factual matrix of every case. So naturally, uh, we cannot have one say for every case. So discretion, to curtail discretion of the judicial bodies, then I think people can predict that the outcome will be this, or they may resort to this act or may not resort to that. As far as the out of the court resolution of out of the court proceedings concerned, this is a vague term. What is out of the court? Out of the court means you can sit in a room and decide like a cabinet. You can engage an arbitrator or a mediation process. But out of the court, doing out of the court, how far it will be effective unless it is stamped by the court or the NCLT or judged by a neutral person. So here I have, view that this out of the court may again complicate the whole procedure, because after going to the out of the court and then people are not satisfied, again they will come to this NCLT and again they will start a process. So what about the timelines and what about the speedy resolution? That will fail. Secondly, we have about the group insolvency detail provision, a separate chapter. But about the cross border, which is the need of the time, which Mr. Madan also spoke about it, because our this law is incomplete, or we are not in the with the globalized trends unless we have a robust cross border insolvency process. I remember that when I was there in the board, I think whole chapter was written. The rules and regulations were made, could have been referred to, and could have been put in. Especially in case of cross-border insolvency, we have less of, as far as the essential legislative functions are concerned, for the purpose of drafting, we have less scope for the delegate legislation and more in the principal legislation, because it is a cross-border insolvency. So only the parliament has the power to debate on the subject, on the provisions, how they will how they will be shaped and what will be the outcome. But here only everything is left to the central government, to the arbitrariness, or to the I should say the executive discretion only, and this is very unfair against the principles of equity. So the two things. One is the cross border. Other is this. Other is this avoidance transactions. Avoidance transactions will not have any effect on the process. It was going on like that, but we should remember that it is because of avoidance transaction. It is because of avoidance transaction the company, I think, is in insolvency. Generally, I'm not telling always. It is in insolvency because of the avoidance transactions. 50% of the cases are like that. So these cases, avoidance transactions are very important, and they would not affect the resolution process. Fine. But what will be the fate of avoidance transaction, and how that fate will affect this process? If the outcome of those applications, it comes out during the whole process, 180 days or 235 days, whatever it is. So this also needs to be, because avoidance transaction is very important and it has been ignored, not no effect. Then what is the purpose of filing those applications? Why to pay attention? Why to consume the good time or the precious time of the judiciary? So these are the some certain points. Other points I will discuss in the panel discussions. Thank you very much.
Thank you very much, madam. Madam, I just
Pawanji, may I take 1 minute?
yeah.
2 minutes. 1 minute on ma'am's last statement, that because of the avoidance transactions only the company have gone into insolvency. But this is the same case where we have been discussing for years together related party transactions.
Yeah.
And you know, the SEBI chair, the then SEBI chairperson also said in one of our meetings that in all the cases of siphoning of funds, diversion of fund of fraudulent activities, the root cause is related party transaction. Now, same RPT is here being called an avoidance transaction, and because of the companies have gone into insolvency. Thank you, ma'am, for bringing up this issue. Thank you so much. And another issue, पवन जी, अभी पिछले 5 मिनट के अंदर ही एक सुप्रीम कोर्ट का जजमेंट मेरे सामने आया है, which has been delivered yesterday only. In case of AVJ Heights Apartment Owners Association versus IIFL Finance Limited, Supreme Court has asked NCLT to submit a report. How many resolution plans are pending before NCLT? For how long they have been pending? And what are the reasons of pendency of these resolution plans? Supreme Court has also directed IBBI to be implemented as a party. And this entire information is to be given within next 10 days, and matter is now listed on 29th of April at 2 p.m. So now Supreme Court also taken cognizance of these delays, particularly in case of resolution plans. Thank you.
Okay, thank you, Mr. Madan. Thank you.
Good information.
Yeah. So I think that is one point which everybody will be active now and collect the data and inform, and then some cases will be solved. Madam, you raise one point relating to definition of any person, any such person. You're absolutely right. I just want to ask one question. When we do the legislative drafting and international or national basis, because when I was doing the Secretary Standard drafting, that time I had read the book on legislative drafting of UK and how and what things you have to take care. Now, tell me, you mentioned that now it will go to judicial body, they will do this, they will read this, they will read between the line. No, any such person is talking in reference to this. It is wastage of time. So why our legislative departments or division are not working differently? Because what you are writing, if it is not clear, you just think that it will pile up in the form of case in the court and it will waste of time. Madam, you have to unmute please yourself.
Jay?
Again, I think, yeah. It is not, yes, up now it's okay.
I tell you, 40% of the cases are because of defective draft.
Yes.
Because of the defective drafting. And for the purpose of interpretation of the provisions, there is a definition section. It has to be drafted very carefully. very, very carefully. For example, in this act also security interest has been defined. And it has been defined the security interest shall not include interest created by operation of law. Agreement is enforceable agreement is contract. You are liable only for the enforceable agreement, only the contract. So that right title interest is created by the operation of law under the law of contract. How can you say that there may be another security interest which is not created by operation of law? I'm surprised. We have defined the security interest. It includes every kind of security interest. But if you want to accept it, then give illustration. Other people won't be able to understand what kind of security interest by the operation of law. Everything is by operation of law. So you will find that there are a number of defects in the definitions. For example, a very simple example I give here only. Definition of registered value is defined. Referring to chapter, I think 17 of the Companies Act, something like that. And that is registered values. There is one section, section 247. Instead of writing chapter, they could have written section 247 of the Companies Act. That is more specific, not the chapter. Chapter may contain 2-3 sections also in future. So if you are defining registered value, then define by referring to section, not by chapter. These are very fundamentals. Cross border, no detailed procedure has been given. Everything has been delegated to executive. It is against the constitution. Essential legislative functions people don't know. I mean, even that in the drafting section, I'm not criticizing that I am the good draftsman, but at least essential draft functions, essential legislative functions cannot be delegated at all. And cross-border is an essential legislative function. It should not have been delegated at all. Only the procedure part, timelines or something that can be delegated. Otherwise, the whole the provision should have been in this act. And that's why I don't condemn. I'm not saying condemning, but at least some more efforts could have been made, because there were good research done initially in the year 2018 and 19 during the times of House Up. So that was not referred to at all. Otherwise, I mean, it could have been a better provision. Again, they have to do some work. They have to come up with the rules. Why rules? Why rules? Why not the act? Anyways, yeah.
Pawanji, on this, I have a question to Dr. Prasad. You are on the drafting. Dr. Prasad साहब, आप तो NCLT में judicial member रहे हैं. Suppose there is some drafting in this IBC court and two different parties are having two different interpretations while the meaning is clear. Can NCLT, being an adjudicating authority, have purposive interpretation of that provision?
Definitely. The purposive interpretation is the key to overcome in such situations. And for that, even if we require, we will open the preamble of the act, look into it, and get guided by the object sought to be achieved by the preamble and vis-a-vis the provision before us. Then take a view on that.
Okay. Manoj, can you just tell us what are the changes with few relating to M&A, some point which will helpful to you, either cross-border or internal?
Good evening, everyone. So, sir, though I think amendments are certain amendments are very important for faster resolution and like group insolvency. It has always been discussion has happened in several cases, like in MTech Auto or Videocon case, but there was no clear provision in the law which allowed this kind of insolvency resolution. And in case of group where multiple entities are there and resolution involves, or the buyer would be interested to have multiple entity within that company to get it resolved faster, I think group insolvency provision was required. And this is a good thing that it has come. Now we have to see what kind of rules or regulations comes to make it feasible, make it possible. So that part is important. Similarly, group cross-border insolvency is also happening. I think ma'am has rightly said that this has been going on, but regulatory framework was missing in the act, and that comes and rules regulation come accordingly. Then it will be much easier and much faster for many of the persons who want to, many international entities or funds which are putting money. So that part is also very important and may help in long-term growth of this process. So I think these two are very important. Other than that, all are more of technical things. CIRP, that means is also one of the initiatives to make it faster. So let's see. Everything will depend upon the rules and regulations. I think draft regulations have also been floated to amend CIRP process by IBBI. So that would also, in what shape it comes, that would make more difference.
Okay. Amit, your view, then I will start question answer.
Sir, I think by and large, Dr. Prasad, Vijayvargi madam and Madan sir has taken us through the detailed analysis of the provision. But by and large, if I can share in a couple of lines as to what is our take on that. The some crux is that we are coming almost after 9 years of hands-on working experience as an insolvency professional, and the expectations which were set up by the industry and the professionals were, I think, little different. As a outcome, what has came
ये अलग है अभी ये जैसे ये
so the outcome which has came from the legislative is in a little different fashion what the expectations were set up. Few things are good. It's a mixed bag. I will not say we are there to criticize everything and anything, but yes, the few things which like scrapping PPIRP and coming out with the new creditor-led insolvency, I'm sure thought must have gone through, but have we really analyzed the reasons of failure of PPIRP? I think that analysis needs to be done, and only time will tell whether this new model will become successful or this model will be another similar precedence what we have experienced in the past. 28A is one provision which perhaps could not be discussed, that I consider was a demand from the industry side. 28A essentially was giving an opportunity to the secured creditor to take possession of the asset which has been provided as a security by the personal guarantor or corporate guarantor. Now, the power has been provided in the law itself that asset can become a part of the CIRP process. I know the challenges will be there, but yes, this was a challenge due to which even PG to CD cases were brought to the light and the provisions were enforced. But implementation again will be quite a challenge. By and large, if I can sum up, the entire change is primarily based on 5 top judgment which has been quoted by Madan sir also, Vidarbha, Rainbow, Amit Metallics, and maybe Byju's also in respect of 12A. So these are top highlights. I think as we progress, as the law is all set to be implemented, I don't see any possibility that it will go for hold or something. So let us await for another round of changes. We will keep on providing our inputs to the regulator, and I'm sure they will consider necessary tweaking as and when they are considering it appropriate at the request of the industry and the profession. I think Pawan sir will take up, I think, remaining discussion in the panel only.
Okay. Thank you, Amit. Thank you very much. Now, sir, I am dividing all questions. I have around 42 plus 45 questions. Okay. And I have categorized also in a different way. Now I will start this. So my request is, because questions are more and we have to cover in for 30 minutes. So I will divide it into two parts. One is a detailed discussion. Second is a rapid round. So some questions which are a small one where we can give answer, we can give yes and no. So I will start with Prashad sir from you.
Can we buzz around also?
Buzzer round. If the questions are remaining there, then we will do buzzer round. But because the judicial member is there and the regulator is there, whether it's a X and present, you have to follow this. So we can't do buzzer round. Before them, what they say is the final word. Okay, sir, the amendment clearly aimed to reduce judicial burden and strengthen creditor control. In your view, where should the line be drawn between judicial oversight and commercial wisdom?
Commercial wisdom.
Okay. Mukhlita madam, your view on this? Okay. Madan, you, any other person?
Yeah, commercial wisdom is supreme, but recently Supreme Court has come out with a pronouncement that where there has been non-compliance of the law or the process, even the commercial wisdom can be re-looked into by the NCLT.
Okay.
The
Yeah.
moment commercial wisdom means the COC would have been exercised the prudence of a degree of ordinary prudent man and come to a conclusion.
Absolutely.
So in that way, I have answered. It is the commercial wisdom which has to be taken.
Sir has given answer without any, because my answer is yes and no. So if you have to take a call, somebody's violated things, other thing, and then they will say, no, sir, I have 100 employees and they will do, it will not be workable. Madam, I will ask this question again from to you. The amendment clearly aimed to reduce judicial burden and strengthen creditor control. In your view, where should the line be drawn between judicial oversight and commercial wisdom?
Again, can you repeat that?
In your view, where should the line be drawn between judicial oversight and commercial wisdom when we say reduce judicial burden and strengthen creditors' control?
I mean, I think the question is very good because the intention of this whole legislation was to reduce judicial, oversight. And the bodies which are in the market, maybe committee of creditors or the professionals, they conduct the whole process and get it judged by the NCLT members and NCLT members, judiciary. That was the thing. The second round of check, because approved by the committee of creditors and the second round of check by the judiciary. So here the commercial wisdom prevailed. Now the thin line which is drawn is that the whole process is outside NCLT. The whole process is outside NCLT. So NCLT should not delay the whole process. On the contrary, nowadays what has happened, because of NCLT, people are blaming that it has been delayed. So I think here something has to be done by the NCLT or the government or all the stakeholders, including the professionals, to reduce this to reduce this delay and get the whole process commercial which is taken outside the court to get it expedited for implementation.
Okay. Is there anything on insolvency of guarantor in this amendment? Madan sir?
Yes.
Yeah.
Yes, it has been provided. I think about guarantors also there is a provision regarding guarantors, but I don't think the provisions which were earlier enacted, incorporated, I think they were sufficient and where the cases against guarantors are going on. But I have one view. Out of the box. Whenever a person takes a loan, there is a guarantee given by another third person on the belief that that fellow will perform properly and would repay back. And that's why he has given a guarantee. He has given a guarantee looking at the situation of the debtor, of the corporate applicant, of the corporate body at that time. But after 4 or 5 years, if the situation changes, then how the guarantor is liable and why the guarantor should be harassed in all these cases. Sometimes I'm surprised nobody will give guarantee then. Nobody will be a good friend. Only promoters are giving guarantee in the corporate. I know that. But if you take guarantee from other corporate body also, then they will not believe you, they will not rely you, or I should say, people will stop giving guarantee, which is the essential condition put up by the banks. Either banks should remove the provision of guarantee so that the guarantors are not being harassed. Something to be done to keep away the guarantors, or
Okay.
not to harass the guarantors. This is my personal view, because guarantors have been roped in. Fine, promoters are guarantors, that's why they have roped in. But the guarantors who are not promoters, suppose, they should be accepted there.
Okay. Okay.
I think that needs to be taken care of.
Yeah.
Yeah.
Prashad sir, timelines have been tightened significantly. Do you think the ecosystem, especially NCLT capacity and IP bandwidth, is aligned to deliver on the timelines? Because I mentioned the ecosystem, if it is not good, then the chain will break. So, what is your view, sir?
NCLT has to first make all efforts to stick to timeline by by mastering the support of the ecosystem. There should be some kind of change in the attitude of the ecosystem in which NCLT depends on working.
Okay. Okay. Madan, you have any view on this, Madan Amit? Those you are going to the court and seeing this?
I think it's an open secret that everybody, and we are before Dr. Prasad, nothing is hide from him. And we all echo that there is an issue of infrastructure and ecosystem. And if at all this wish list of tight timeline has to be adhered to, it's a good wish list, then the ecosystem has to be strengthened. There is no second thought on the same. If it is not done, then it will have the same fate what we have in the last 9 years of time.
Okay.
Whatever law we want to create, we can create. But in practical terms, unless and until we create the necessary ecosystem, what is required to achieve those deliverables, it will not work.
Okay. Madam, I'm just asking one question because you were in the IBBI when the NCLT has given this IBC work, and then first you have given that work. Second, you have put in them responsibility that you have to do this within this period.
Yeah.
Now, then what is the reason that government is saying we have to protect the interests of the falling companies or those who are going to insolvent and they will lose business, government lose money, employee will lose employment. Then why we are not focusing on increasing NCLT benches or NCLT members? What is the logic behind this?
Whenever you establish any office in the government, or if you are a government appointed persons, certainly the pay will be out of Conservative Fund of India. If you have fiscal deficit budget, where you find that you have taken loan from the World Bank, or you have managed somehow day-to-day working of the government, though we have a 8th commission and we have increased the salaries, but we have not increased the benches. It is very surprising that justice system is a very important system in India. And I think if you are satisfied, if you derive justice, social, economic, political justice we get from the enactment of the law. The first platform for the justice is the enactment of the law. The second platform of justice is the courts. Certainly the second platform of justice is important because people are less concerned about what law you enacted. People are concerned what remedy I will get in the courts or in the tribunals. So naturally, as per the population, we compare with the other countries, the judges number is very, very less. Even I think doctors are more, not the judges. The doctor, treats you and gets you well, but we have less number of judges, so we can't provide justice to the stakeholders of the parties who are aggrieved. Or here, I think government has to pay attention, but maybe there may be certain constant restraints about the exchequer, the money, the establishment, and I think the people, competent people, they should have, and I think the people who are appointed, they should be. I'm not talking of the judges or not criticizing, but at least they should be talked about the spirit of that law, which they are dealing with. What is the spirit? If it is a law which is going to the direction of the inquisitorial method of doing justice and not adversarial method of doing justice. So they should taught this is inquisitorial. You cannot put again and again the delay, adjournments, or listen the other party. If you are given chance, one chance, two chance, then you should not give the other chance, or you can intervene in between. So that way this law was put in. It will establish, I think, not the foundation, but at least it will establish an inclusive system of justice in the country. But somehow, because judges are from this bench and bench is dealing with the adversarial system of justice, so they have also applied that kind of mechanism even in applying or interpreting the provisions of this law.
Absolutely right. This is rightly pointed out. Doctors are doing the surgery of a human being, and they are protecting the human life, and the judiciary is protecting the society as a large. Both has a,
Especially the corporates one,
yeah,
corporates, the life of
both,
corporates.
yeah, both has a different role, but they're in India, the medical system is like this because my son is in Dublin. So to get a one your test or your any ultrasound, another thing, they are giving 6 month date. And here in India, you go to any corner of the any street where the ultrasound is there, go and get it done and come back. So that way the system is there in India. Same thing, we have to do something to judiciary. That less we will discuss this in some other forum.
There's a lack of intent on the part of the government. And secondly, madam, talk about the money. I think in NCLT, any damn application can be filed by paying a fee of 1,000 rupees, and majority of the applications are frivolous. You have a filing fee of 25,000 rupees with the application. You impose heavy costs on the mischievous and frivolous application. You will have the money. You know, when Dr. Sahu was levying a fee of 0.25% on the insolvency professionals, I gave a suggestion at that point of time: don't charge it from the IPs, charge it from the SRAs. Have 1% of the resolution plan amount with IBBI. No SRA will mind paying 1% of the resolution plan amount to IBBI. Create that corpus and then spend it on the infrastructure. We have to come up with the various ways and means to have the infrastructure.
Mr. Madan, we have a provision that the penalties which are deposited, maybe the in the courts or the tribunals, they are to be remitted back to the Consular Fund of India. That is the process.
Whatever,
No,
whether I keep in this pocket or this pocket, the court is mine.
No, sir. If you are charging penalties and you can make a fund of that penalty and then spend on that particular theme, on a particular subject matter or particular operation, that is good, because then the government need not worry about the exchequer or treasury or whatever it is. So I think that is the position in other countries. In other countries, if something is received by a particular department, that they spend in the department, not that they are deposited in they deposit only 10% of that amount to the consumer fund of their country.
Okay.
Yeah.
Now, the introduction of definition of avoidance transaction and fraudulent of wrongful trading, how does this improve clarity in litigation and reduce interpretational dispute?
There's no clarity is not required. Actually, it says whatever they have said, what is there in 43, 45, 49, 66, that will be their avoidance transaction. It's a clarification only.
Okay. With the introduction of creditor-initiated hybrid process, are we moving towards a more efficient system or creating parallel complexity? Prashad sir.
Sir, you are.
This is only an attempt. We have to wait and see.
Okay.
This is an attempt, but good attempt.
Okay.
Apart from the regular approach, this is a good attempt. But whether it may lead to same regime of BIFR or not, we have to wait and see.
Okay. Madan, the clarification that security interest must arise from the agreement, not operation of law. What implication does this have on statutory dues on government claims?
Actually, what has happened recently after this rainbow matter, when the GVAT says that any amount outstanding to Gujarat VAT authorities, and they will have charge over the assets of these SSC. And after that, many other judgments came. We have seen Prabhjit Singh Soni judgment, Noida, Greater Noida Authority, if they have to say have some money from the corporate debtor, against that money they will charge over the assets of the company. Now the definition says nothing doing Security interest simply means security interest created by virtue of an agreement between the two parties and not by creation of law. So that ambiguity, right or wrong, that ambiguity has gone. I'm happy with the clarification. Right or wrong, I'm not commenting on that, but I'm happy
Okay.
with the clarification.
Now, admission and initiate stage. The amendment restrict AA from rejecting application beyond a specified ground. Does this significantly reduce judiciary discretion? Sir, Prashad sir?
Yes.
Okay. The recognition of information utility records as sufficient proof of default. Will this make IU infrastructure central to insolvency practice? Amit or GP, anybody?
Absolutely, yes.
I
Even if
think,
you read today's newspaper, it says that IU may become a university also now. And all
Okay.
the operational criteria will also be mandated in the times to come to report the default to the IU.
Okay. Time-bound admission with mandatory reasoning for delay. Will this provision be enforceable in practice? Anyone?
Yes, it
Yeah?
can be.
Yeah, okay. Okay. Withdrawal of CIRP. The prohibition on withdrawal before COC constitution, after invitation of resolution plan. And how does this change negotiating dynamics between creditor and promoters?
It is not going to be practically possible to have this provision now because first of all, constitute COC, then have 90% of the vote of the COC in favor of the withdrawal, which is not going to happen.
Okay.
For all practical purpose, this will not be implementable.
Okay. Does this amendment strike balance between settlement flexibility and process sanctity?
Sorry, question is not clear.
Sir,
Can you please repeat your question?
Sir, does the amendments strike a balance between settlement flexibility and process sanctity?
To some extent, the process sanctity will be there.
Okay. COC now supervise liquidation process. Does this blur the distinction between resolution and liquidation phase?
Yeah, I think whatever result will have a more clarity now.
Okay. Requirement or record reason for approval of resolution plan. Will this increase litigation risk of COC decisions? Amit?
no, I don't think in any which case currently also means the justification and the analysis is already there. It's only matter that you are moving one extra bit for the purpose of before you are recording that. So I don't see that it should be a problem.
And I tell you, in the year 2017, Supreme Court has already clarified that all the timelines for the adjudicating authority are directory in nature. So whether you have these 14 days, 30 days, 3 months or not, Supreme Court judgment will prevail over all these timelines. आपने मिस कर दिया आंसर शायद.
नहीं मैंने सही किया, मैंने सुन लिया. मैं आपको दूसरा क्वेश्चन पे आ रहा हूँ क्योंकि मुझे मेरा फोकस क्वेश्चन कवर करने पे है.
बट इसका मैं एक राइडर डालना चाहता हूँ.
Yes, sir.
What has been felt by the Supreme Court is now slightly modified by the legislature.
and
some kind of legislative force.
So this tussle will continue. Who is supreme, whether legislative or judiciary, or executive?
Correct. But when we talk about separation of powers, all have to work independently within their regime. But as far as the legislative intention is concerned, the onus is on the judiciary to translate the legislative intention into a practical regime.
Sir,
that is what I want to say.
Sir, you said separation of power or suppression of power?
Separation of powers.
Separation.
Okay. Provision for disciplinary action against RP and liquidator for failure of report transactions. How will this impact professional risk?
Sir, please don't ask this question to me.
Yeah.
Okay, so both the professionals are silent. So
why I'm silent? Because for any petty technical non-compliance, our regulatory taking action against insolvency professional, that is very, very unfortunate. I'm saying it with full conviction. Barring, ma'am was very liberal when she was DC and passing the DC orders.
Okay.
But I confirm the views of Mr. No, Madan.
Okay. Now, resolution plan framework. Protection of dissenting financial creditor based on liquidation value versus distribution waterfall. Does this settle the fairness debate post judicial precedents?
Absolutely, yes, because this matter is already pending before the larger bench in Supreme Court. I hope that matter will get settled down once this amendment is notified.
Madam, your view is also on the same?
Same, yeah.
And the last sir, judicial view?
I too agree the same. The
Okay.
same view. No,
Okay.
there cannot be second opinion for this.
Okay. Allowing separate approval of implementation distribution, is this practically workable?
What's the question, please?
Allowing separate approval of implementation and distribution. Is
Very
this
difficult, very difficult to be implemented.
okay? Establishment of all pre-approval claim. How does this interact with ongoing tax or regulatory proceedings?
This is the need of the hour. It's a welcome amendment. Rather, it is already there in the code, but it has been more clarified in a much better
Okay,
way.
Manoj, what is your view on this? Because you are handling the M&A merger, M&A tax cases.
Right. I think I concur with the view of Madan sir. This is practically, yes. Fully.
Okay, guarantor and third-party asset section 28A, allowing transfer of guarantor asset during CIRP. Does this effectively integrate guarantor insolvency with creditor insolvency? With corporate insolvency.
My practical experience says guarantors' assets details are not with anybody. Because whenever the banks are taking guarantee, they are not taking the list of the assets and more of the list of the assets which they have taken that has become very old by the time the company goes into CIRP. Now you are saying along with the application, you have to file this and give the entire list of the assets owned by the person. Don't think the provision will be practically possible.
Practically, it is not practical, yes.
Okay.
I think.
So, Prasad sir, how will conflict be resolved when guarantor is undergoing a parallel insolvency process?
First come, first basis.
Okay. Madam, you have any different view on this?
Hey, you asked me, sir?
How will conflict
Yes.
be resolved when guarantor is undergoing parallel insolvency process?
I think I agree with Mr. Prasad.
Okay.
But certainly it will open up Pandora box.
May further.
Yeah.
Amendment
Your voice is mute, sir.
Madan sir, your voice is not.
Section 96 will give. But
just repeat.
I'm not audible.
No voice.
Am I audible now?
No.
Madanji, you are not audible.
Madan, you drop and then come back.
Still not audible?
I think.
Now audible, yes.
Or there is a gap.
Audible?
Yes.
Audible, but voice is coming after when you say. So there is a gap.
May I speak? May I speak? If you can hear me, may I speak now?
Yeah.
Yes.
Okay. Section 96 moratorium will go. If an application is preferred under 94 or 95, interim moratorium will go. But if as the final application under 99 is admitted, report under 99 is admitted under section 100, moratorium under section 101 will kick in. And the moratorium under section 101 kick in, all other proceedings of personal insolvency and other courts will get abated for the time being.
It's okay. You are speaking from the angle of moratorium. Question is specifically when two parallel proceedings are going on.
So this proceedings will prevail over the other now.
Okay. Let's go ahead.
Yeah. Replacement of liquidator through COC section 34A, does that strengthen creditor control or create instability?
I think that is okay.
Okay. Mandatory timeline for acquisition, liquidation 180 plus 90 days. Is this realistic given ground level challenges?
Not practical.
Not at all. Not at all.
Okay, madam, what is the solution for this?
Oh, this timelines, I think, would not be possible to be, observed. And I think some more timeline should be given because liquidation means summing up everything. So, and submitting the report also. So that will take more time. And I think if we ourselves experience, we can't sell even if we want to sell a cycle, then also we find difficult. So in that case, if he is going to recover money through auctioning or selling something. Its timelines are too harsh here.
Pavan sir, as you mentioned earlier, unless we work on the ecosystem, these are going to be only paper tiger. That's it.
Paper tigers.
Sir, practically, even in the best of the economies where this insolvency laws are well settled, liquidation and disposal through the administrator takes years. It is not only in India.
Madam and
Worldwide,
Prasad
it is the
sir,
same.
my one view is there. No doubt, these are the some exceptions which can create problem. Can't we do this way? Like I am asking this question and everybody is saying, no, this is not possible because entire world it is happening something. We can make the cases which are clean, which can cover in the 180 and plus 90 days. Some cases are not in this category because of some reason. So we can make when we are writing something, when the IBVI submitting its report or NCLT submitting, we are saying majority cases we are doing this way, but these are the cases because of this reason this is happening. So something otherwise, what is happening? The sanctity of this 180 and 90 days is going down because of few cases, not in all cases. So my question now, my counter question: in all cases, 180 plus 90 days not possible, or in few cases?
In few cases only, practically speaking,
Yeah.
your observation is correct. In few cases, it is not possible. It is not that universally it is not possible.
Yes, that's right. So we have to make this way, and we should try identify these type of cases and do it, because when somebody is talking to the market or regulator, they are saying, sir, this is not possible practically. Maybe one case, 10 case they have done better in within that timeline.
But
But the practical problem is that whenever the law makes certain things which is not practical, and because of that 1 or 2 cases happen which is not within that limit, the sanctity of law goes. So why to make such a stricter law, or you may make 2 laws. Let's say for certain things fast track process is there, but for all others this will be the normal timeline, and it will be through the judicial process only, or through administrative process, whatever it may be. So you are yourself creating a certain strict timeline and then missing those timelines.
And it is shifting the general perception as well.
Okay, now the new question. New rules are on secured creditor, mandatory intimation within 14 days. 66% approval for enforcement. How will this impact enforcement strategy now?
What is the question, please?
New rules on secured creditor, mandatory intimation within 14 days.
Intimation to whom?
To secured creditor.
Huh?
Post commencement of CIRP, intimation to secured creditors.
Okay.
And 66% approval for enforcement.
That is already
Which enforcement? I think question is not.
This second part we are not able to.
Question is not clear to me.
Okay, leave it. The provision for restore CIRP even after failure, does this introduce a second chance mechanism or delay liquidation?
No, it's a welcome provision.
It's a good thing.
Yeah. Restriction that restore can happen only once. Will this limit misuse?
No,
No, that is not.
Madam, what is your view?
Not.
Yeah?
Apparently not.
Okay. The clarification that statutory dues may not allow qualify as secured claim. How will this impact government recoveries?
The objective of the law is not a recovery, and number 2, particularly not for the government at all. Government
but government has a pressure to the when they're internally talking. Suppose madam is making law, or madam is in IBBI, when they were talking to the tax division or other regulatory division, they must be asking this question. So, madam, what is your view on this?
I mean, whatever I have drafted earlier, that is my view, because government priority is should be the last, and the creditors priority should be the first, or the operational creditor priority should be the first. I think that was the intention and should be kept maintained.
Okay.
From the very first day, this is not a recovery forum. We have to understand
moreover, this is nothing clarificatory in nature. Since day one, since the inception of IBC, government is at the bottom in section 53.
Okay. Now rapid round. I will have to start because we have to finish this fast. clarification that this treatment of parallelly secured creditor, does this bring more equity in distribution?
Yes.
Okay. Introduction of creditors initiated process chapter 4A. Is this India's version of a debtor in possession title model?
To some extent.
Okay. Okay. 51% threshold for initiation of versus 66% in traditional CIRP. Does this dilute creditors consensus?
21%.
It is
51%.
Isn't
CIIRB we are talking about.
It's okay, it's fine.
I
Okay,
think
management continue with the board during process. Does this increase moral hazard?
it's not about moral
No.
hazard.
It's
If
an
the revival happens,
experiment.
that's good for
You know,
industry.
all these questions are premature. Let's see the regulation. Let's try to
Right.
implement them, and then we should discuss all this.
No, that is right, but we are here to see what is the otherwise
But we
have
are,
to-
we are
But you know,
discussing like parliamentarians are talking in
Kawaljeet,
the
there are
parliament.
many
This is not
amendments. There are
correct.
many amendments in the existing provisions. So it's better we should concentrate on those rather than something proposed which is subject to certain
Okay,
regulations.
the reinforcement of the clean state principle brings clarity, but does it also create concern for operational creditor or unresolved claim?
Not at all. Otherwise,
but
nobody will
on-
come for a resolution.
But on the other hand, for last 5 years, the government has been saying we need to do something for the operational creditors.
Correct.
And they have again missed the bus. I submitted it to the select committee also that you have not done anything for the operational creditors.
Correct.
Okay, group insolvency and cross-border framework are progressive steps. What are the immediate practical challenges you foresee in the implementation? Manoj, you tell me.
Sir, I think practical challenges we will discuss only when the rules are there, regulations are there. Regulations are not there, so we cannot say what law they are prescribing. It is just enabling provision.
Okay.
I think, and just to add what Manoj was saying, over a period of 9 years, judicial forum and judicial member like Dr. PSN Prasad have already evolved the group insolvency concept, maybe in some different way. Maybe it was not a legislation, but now I think that has been given a shape, nothing else.
Okay. Will these amendments improve recovery rates or just procedural efficiency? Madam.
procedural efficiency.
Okay. What will be the impact on P strategic investor stress assist fund, Manoj?
Sir, I think
Yeah.
CIIRP regulations should come and then we will see whether it is making any sense to investors. Otherwise, all other processes are almost the same. I don't think there may be, yes, intent is clear that they want to create efficiency, but whether it is practical or not, we have to see. Then only
Okay.
investors would be interested.
Madam, does the code now tilt to more towards creditors control or balance approach?
I think creditors control.
Okay. Prashad sir, do you think changes reduce or increase scope for litigation in early stage?
See, the changes will definitely decrease the litigation,
Okay.
provided the supporting rules also gives the enabling support for the provisions.
Okay.
As of now, the object is to see that it creates a kind of deterrence in the debtor, not to go under IBC process, but to settle the matter with the creditor.
Okay, now it's a time to close. So I will pose one question and everybody can give answer on this particular thing. If you had to identify one reform in the amendment that can truly change outcome, not just process, what would it be? I'll start with Manoj.
Sir, I think very difficult to say, but practically, yes, enabling provisions are good and intent is in the right direction. But I think we have to see what happens practically. Utility life is very important if we are putting the system in place and it works properly. Then yes, it can be fast tracked.
Okay, I mean,
utility's role would be
I
important.
wish it could be a debtor in control model, what has been tested, as Dr. Prasad was indicating. It is in testing stage, but if it is successful, it can be a mega reform for India.
okay, Madan.
Positive is another attempt for revival of the company before sending into liquidation.
Yes.
Negative is sending the solvent company to insolvency by replacing the word may to shall in section 7.
Okay. Madam, your view.
My view is that I welcome these amendments with certain modifications that it requires. Otherwise, I think we have moved ahead because there was no group insolvency provision, and at least they have mentioned about the cross-border, not fully, but I think in times to come in the next amendment process, I think they will insert. Anyways, I think these amendments may be based on the stakeholders' comments or the stakeholders' requirement, which they used to meet. I mean, people might be meeting chairperson or it may be representing. So maybe the market requirement, but there are certain duplications and it could have been drafted in a proper or better way. For example, one more point I wanted to raise and I wanted to ask you in the end that whether the resolution professional needs to verify claims. There is a provision in this new amendment act that he will collate the claims and then he will verify the value of the claims. He can appoint valuers to for the valuation of the assets, but he cannot himself verify the claims and the value of the claims also. That is very surprising. I think you can go to section 18 and there where the explanation has been added in the amendment act and which says about the IRP has to value the verified claims also. So this is very surprising. How will you value? There is a valuer. Naturally, he has to see the services of valuer. So how he will value? Because first he will collate and then later on appoint for the valuation of the assets, not of the claims.
Okay. Okay.
Yeah. So
Prashad sir, your final word.
My final vote is cross-border insolvency, which was trying to see its light from a long time. Now it has just given a light, and also the group insolvency supported by the rules and regulations, whatever is relevant. But this amendment has a great lift for these two.
Okay.
Cross-border as well as group insolvency.
Thank you very much, sir. Thank you. Thank you all. As we conclude, one thing is very clear. The insolvency code is no longer just evolving. It is maturing now. That is sure. And the way discussion we are doing, we are not doing discussion on the initial thing. We are talking about the cross-border. We are talking the group companies. We are talking about the creditors and other issues. And we are not talking about the timeline. We are talking about the greater value. So these amendments, when we follow this and doing this, it is clear that now it is process to outcome, from legal structure to commercial discipline, from court-led resolution to creditor-led decision making. It is shifting. The intent is very, very clear. It is progressive and it is aligned with global practices because now you have your target to achieve this. But the real success of these reforms will depend upon two things. One is institutional capacity, which we are lacking. Stakeholders' behavior. Here is also some problems are there. And the discipline implementation. Now, all these three things are there where we have some problem. So when we talk about any successful implementation process, then one thing is sure that ecosystem should be strong. And these three things, institutional, stakeholders, and the whatever decision is going on, it should be implemented in a disciplined manner. If it is a lacking, then you can't reach to somewhere. We have to increase the capacity of the NCLT members, NCLT court. We have to make the law which has a clear-cut clarity on this, not confusion. And whatever implementation we are doing, we understand the market scenario and then implement. If these align, IBC framework can truly become a global benchmark, which we are expecting to reach up to that level. With these things, I thanks all my panelists, Dr. Prashad, Muklita Madam, Madan, Amit, and my all participants. And I am sorry for this because Madan has insisted that this program we have to do on this Friday itself. And Otherwise, we were having a plan for next Friday, but though it is now clear that whatever we are doing, we just try to do as early as possible so the market and professionals should understand fast. Some of them has given me comment also that we are not reading law. We are aware that you will organize programs, so we'll understand everything. And we are sharing our presentation also. So you can see, and then it is available on YouTube also. So whenever you want, you can go back and anytime you can see this. With this thing, thank you all. Thank you very much, all my panelists and participants. Friends, this journey of knowledge sharing will continue. So next Friday, 4 p.m., we'll meet again with a new topic. I'm not announcing topic because there are 3 topics are coming. So we are just working out which one is the best and most suitable and required need of clarification. We'll do it. So Monday, everybody will get information. Till then, goodbye.